So at this point in the class, what we would like to do, what's the logical progression, is to go into the hiring process. We spent a lot of time defining the employment relationship, talking about what the employment relationship is, how it's grown, how it's changed, and how do we know who's an employer and an employee. And so at this point, we should start with the hiring process because that's the onset of the employment relationship. But before we can get there, we do have to take a slight detour into studying anti-discrimination law. Because although we'll spend a lot more time on anti-discrimination law later in the semester, for now it's important to look at it because so often discrimination can occur during the hiring process. So in order to understand the hiring process, we need to look at discrimination law. And so in today's class, we'll start with a notion that the employment at will doctrine, what we said is the legal theory that underlies employment law in the United States, does not apply to cases of legal discrimination. So employment at will, the idea that you can hire and fire without regard to any cause, for good cause, bad cause, or no cause at all, it does not apply to cases of illegal discrimination. And in the United States, Title VII of the Civil Rights Act of 1964 governs illegal discrimination in employment. The other statutes that we'll talk about later, the Age Discrimination in Employment Act and the Americans with Disabilities Act, those are both modeled after Title VII. So understanding Title VII will help you to understand those laws as well. Now, we know that despite laws against discrimination, again, we're talking about 1964, it was a long time ago, we're all living in a post-Title VII world and have lived here for almost 60 years. Despite that, we know that employment litigation continues to grow, and we continue to see more and more discrimination claims brought. So understanding Title VII and how it works is vital for all business managers. So in this lecture, we're going to look at what Title VII is, what it does, and how do we prove an illegal discrimination case. Because proving the case is a guide to tell you, as a business manager, how to respond, how to prevent illegal discrimination from occurring. And if there is a claim of discrimination, illegal discrimination, then it's up to you to be able to show that they cannot prove the case. So we're going to spend some time talking about how do we prove the case. Before we go there, however, we talk a little bit about the background of Title VII. Title VII, what does it do? Well, it protects against employment discrimination on the basis of membership in protected classes. And so this concept of protected class is something that we're going to spend a lot of time talking about in the lecture. Now, Title VII protects 5 classes. That is race, color, sex, national origin, and religion. Title VII protects against discrimination. What you need to understand about Title VII, which people often miss, is that Title VII is completely agnostic in terms of its protection. It protects black people, it protects white people, it protects Mexican Americans, it protects Italian Americans, it protects women, and it protects men. So Title VII is not about affirmative action, it's not about protecting minorities. Title VII is at its heart about equal employment opportunity. And therefore, it's completely agnostic as to the idea of minority or not. They just want to see, the courts and the EEOC are going to want to see, was there discrimination based on membership in a protected class? The idea behind Title VII, of course, is that we give up thinking about those protected classes, that we make decisions on the basis of whether it's good for our business or not whether it's based on a factor beyond your control. So what does Title VII say? It says it shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against the individual because of their race, color, religion, sex, or national origin. So Title VII's protections said, Title VII is a pretty minimalistic statute, but we know that Title VII's protections, what it means to not discriminate against people based on membership in a protected class, we know that this means that employment requirements have to be uniform and consistently applied. Title VII also prohibits offensive conduct that alters the condition of employment. We'll spend a lot of time talking about harassment in here. We'll focus on sexual harassment, but of course harassment can occur for any of the protected classes. And so I could bring a claim for racial harassment or national origin harassment or religious harassment. The reason why that those are prohibited by Title VII is that because those change the conditions of employment depending on membership in a protected class, then that's discrimination. Title VII also prohibits discrimination in compensation. It protects against physical segregation based on a protected class, and it protects employees who make a complaint from retaliation. Retaliation is a growing area of discrimination law, and the prohibition against retaliation is based on the idea that we want to encourage people to make a complaint, and we don't want people to be harmed simply because they made a complaint. And in fact, with retaliation, if retaliation occurs, even if there was no underlying discrimination, as far as the law is concerned, it's the same thing. It's the same thing. Now, Title VII does not apply to every employer. Because it's a federal statute and Congress has limited powers to regulate employment, it can only regulate employment that affects interstate commerce. And in order to determine how big an employer had to be before it affected interstate commerce, they simply drew a line at 15 employees. So in order for Title VII to apply, an employer must have more than 15 employees. Now, let me give you one big warning here. Every state has a law that is equivalent to Title VII. There are 50 different state anti-discrimination laws. And many of those laws will extend to more than Title VII. For instance, in Oklahoma used to have the same requirement for the state law, had to have more than 15 employees. But all that changed back in 2010 when the state changed its statute to say that it reaches every employer. All you need is one employee. Nevertheless, for Title VII, an employer has to have more than 15 employees. Make sure you know that. That's an easy question to ask. Some institutions may be exempt. We'll talk a lot in here about religion because that's the largest class of exempt institutions. In essence, what this means is that religious organizations can discriminate on the basis of religion. Again, we'll talk a lot more about that, but understand that in the statute itself, a number of employers are removed from coverage simply because they are religious organizations. Finally, independent contractors are exempt. Remember, we spent a lot of time talking about employee classification, worker classification. Are they an employee or are they independent contractors? And the fact is that for independent contractors, they do not have the protections of Title VII. Theoretically, you can pay less than minimum wage to an independent contractor. You can discriminate illegally against a independent contractor. Not on the basis of race, which we'll talk about as a special exception, but theoretically on the basis of sex. In essence, independent contractors, although they may have other claims, they cannot bring a claim based on Title VII. And again, make sure you know that for your test. If you see someone who's not an employee you will know that they cannot make a claim based on Title VII.